Article 7 of the DSU, the panel is limited to the panel request. There is a condition to use local over imported goods. The accumulation of origin rules were established under the OTA, and both parties, Zyklon and Telon, agreed that the Solaris and Solaris product shall be treated as originating and therefore domestic and subject to zero tariffs.
I'm very excited and glad to be here in Nairobi, Kenya, as one of the participants representing my university in the WTO law contest. The WTO law contest to me is of a very robust significance to me. Over the years, I've been trying to make considerable efforts in widening my horizon on the international trade system. I would like to say that there is a need for you to have, number one, an enthusiastic interest in WTO laws. Indeed, the WTO law is not within the domestic laws that we study in our universities, but then there is a need for you to develop interest, a very keen and trenchant interest in international law, especially as related to international trade system. That there is no exception under Article 20.
The African regional round of the John Jackson Moot Court holds a very personal, a dear aspect in my life. I've been a participant about 2 years ago. I've also served as a coach, and now I serve as a panelist. And it's remarkable to have been involved on all the levels of, all the parties that are relevant to this competition. This year is particularly significant because of the huge number of teams that are now participating in the African round. And it's telling of a promising future in terms of Africa and its place in international trade. So I would like to encourage the students not just to leave it here at the Moot Court. There are very many opportunities in terms of trade law and policy. So if it is your passion, then stick to your passion and follow your dreams. Hopefully I'll see you on the other side.
With regard to the first year, Article 5B is an external requirement, whereas Article 8B is an internal requirement. By external requirement, Article 5B...
We are very, very impressed with the caliber of students across the board. Throughout the competition, it's a fairly consistent level of education, I think, of the ability to stand up and moot. Obviously, they've practiced a lot, and I recognize that some of them have never studied WTO law. They've done it all themselves, so they just take the materials and did it by themselves. So they're real self-starters, and it's a pleasure to work with them all. King & Spalding is a broad sponsor of ELSA and the John Jackson Moot Court competition worldwide. So this year we participated in every region and every round, and so we have a very good idea of the talent that we can compare the African round to. And what it means for us to participate, I mean, we sponsor this because it's the area that we work in. So we identify talent, we hear what's going on in the markets, we meet with people while we're here, but most importantly, we interact with the students who are the future of the profession.
Could you say that in either of the articles, whether it's in 1.1 or 3.4, we should apply the test more strictly? Is there any place between the two, that is, where we should apply it more strictly or a bit more loosely?
Oh my God, it's so amazing being here. This is a phenomenal experience of which I don't wish any law student not to miss. You guys, I urge anybody out there, a law student, to actually participate in this Moot Court competition, because here being here is so amazing, interacting with other law students. Oh my gosh, I can't even explain how I feel right now.
Moot courts have always been an important component in the teaching and study of law. And I must say that what we are seeing in the recent past is very significant in terms of upscaling the level at which young men and women who are practicing or intend to practice law are being exposed.
The best oralist for the semifinals, the award goes to Michelle Musili.
The best oralist finals, which was a tie between Michelle and I, and then this is for the best oralist semifinals, which was Michelle's award. Catherine got best oralist in the preliminary rounds, And then, of course, there was the awards for the winning team, which are currently with our coach.
It's a fascinating experience. We have seen a great deal of talent here, and I think there is a glass wall that must be broken. There are voices of talented young African students, particularly young African girls, that must be heard. So I think there are bridges to be made between Geneva and Africa, and I think the WTO, the International Trading System, would benefit greatly from new and fresh voices such as the ones we heard these days.
True, I completely second Carlo on that. I think Africa is one of those continents which is emerging now, and to bridge the gap, we need young students like this who would go on to become good trade lawyers, or even lawyers for that matter. And it's been an experience for me. It's surreal. I really admire their dedication, coming from not even having done an LLM. Some of them are undergraduates, and the effort that they've put in is like mind-blowing.
I think throughout the competition I was much happier to be a panelist than a participant. It is much easier, honestly. Just to echo what Carlo and Tamal were saying, I was very impressed with all the performances from all participants. There were of course some better than others, but I always saw lots of determination, hard work, and it really gives me hope and inspiration for the future.
Well, as we speak, the negotiations on fishery subsidies are taking place in Geneva, and I think that is an aspect that is on which we would need desperately fresh voices. So I would think of a problem on those issues, definitely.
I think given the current environment in international relations, one of the central themes that will have to be explored in future years has to do with the role of the security exception in the covered agreements as a means of regulating international trade. So I think that's something that will be relevant in the years to come.
For me, I think the trade and climate change and the interplay of it is quite a relevant issue, and we see the effects of climate change, and that has of course got to do with kinds of goods you produce and the greenhouse emissions that comes out of it. And it is a topic that is quite close right now, and especially developing country members are often said not to take on their share of responsibility or shoulder their responsibility. And as such, not only Africa, I think countries like India, Brazil, South Africa would have much to offer, and I would like to see questions, or like to even have answers to these questions as time progresses in moot courts like this, or even in forums with conferences and things.
It is a great privilege for the Kenya School of Law to have been chosen to host the John H. Jackson Moot Court Competition African Rounds this year. We are privileged to be hosting delegates from all around the continent, as well as panelists and others from around the globe. The Moot Court Competition and the subject that it tackles of international trade is a very relevant one at this time. With the developments going on regionally and internationally, we've got the African Continental Free Trade Area about to enter into force with the ratification of the agreement. Regionally, we've got the East African community engaging in deeper integration. So with the need to build capacity around the continent on international trade law, I think this is one avenue that will go a long way towards that end.
Many African countries, they face major challenges in utilizing international trade law for their benefits. That's not only on the context of WTO, but also in the bilateral and also regional levels. So international trade by itself is very complex because it's interrelated with the legal, technical and economical aspects of it. So it's very complex. And as you well know, the universities, sadly, they don't even have a curriculum on international trade. So the competition for us is very ideal for the students to know exactly what happens, and also for them to endeavor into studying the international trade law further, and also get the network so that they can be able to understand this better. So at the end, our objective is to have trade law experts, because as you know, the AFCFTA would need that, because we would want to have future trade negotiators because it has a big advantage for Africa now.
I think we have around 6-ish weeks before we come to Geneva, and we're really looking forward to coming, and we hope to have really improved our substantive arguments and oral advocacy. So we hope we can give you guys great competition and maybe even win in Geneva.
I think on my part, the greater thing is that it's not just us, but Africa as a whole when we go to Geneva. So I think they should expect great competition from the African teams, and may the best team win.
I'm looking forward to learning from them as well as them learning from me, because we all look at the same thing in different issues. And yeah, I just hope it will be fun competing against each other, and let's see whoever wins.